United States District Court, Central District of California, Western Division, Jenny Flores et al. In plaintiffs versus Merrick, Garland, Attorney General of the United States of America, and defendants, aka Biden-Harris administration. This was brought forth by the Center for Human Rights and Constitutional Law, National Center for Youth Law, and Children's Rights. So, the U.S. Customs and Border Protection is holding Flores class members outdoors in open-air detention sites along the U.S. border in extraordinarily unsafe and unsanitary conditions. Children have spent anywhere from several hours to several days at these sites before Border Patrol transports them to brick-and-mortar facilities for formal processing. Children in these open-air detention sites are in the legal custody of Border Patrol and are therefore entitled to the full protections of the Flores Settlement Act. Since at least February 2023, Customs and Border Patrol has held children in open-air outdoor sites. Both accompanied and unaccompanied children are held at these sites. CBP directs class members to remain at these sites for indefinite periods of time while they await formal processing, holding children overnight and in some cases for multiple nights. Plaintiffs are currently aware of at least 7 open-air detention sites within California in the Border Patrol San Diego sector. 4 of these open-air detention sites are located west of San Ysidro. I don't know if I'm pronouncing that right. Sorry. San Ysidro port of entry between the primary secondary U.S. border walls. The other 3 are located outside the remote desert town of Jacumba and are monitored by Border Patrol agents and surveillance towers. Children are held at these open-air detention sites in deplorable conditions. Border Patrol provides no shelter at OADS, and children are left exposed to the elements. As a result, people sleep in dirt littered with garbage, exposed to scorpions, snakes, and insects. Some children and other non-citizens have resorted to sheltering in porta potties and dumpsters to escape the wind and rain. Volunteers provide tents and tarps, but there are not enough, and conditions are unsanitary. The temperature variations are extreme. It can be very hot and dry during the day, and it can drop below freezing at night. CBP occasionally provides mylar blankets to detainees, but no other protection from the elements. Children are at particular danger from exposure to the cold temperatures. People held at these sites have no choice but to burn brush and garbage to try to stay warm. Non-citizens and volunteers experience watery eyes, a burning sensation to their throats, black mucus coming from their noses and throats, and other respiratory problems. The conditions at OADS are grossly unsanitary. There are no permanent toilets or showers, and Border Patrol fails to provide people with basic hygiene items. Border Patrol very recently set up hand washing stations at certain OADs, but some were filled with trash. Although CBP has set up some portable toilets, they are not regularly serviced, and few porta potties provided are insufficient for the number of people who need them, making them quickly unusable. Even if porta potties are usable, they're often unavailable because the weather conditions are so severe that children and others crowd into the filthy porta potties to escape the wind and cold. Some OADs have dumpsters, but these dumpsters are not regularly serviced and the sites are filled with garbage. Children and others nevertheless attempt to shelter in dumpsters to escape the cold. CBP fails to provide children held at OADs with minimally adequate food or water. Despite holding children at OADs for long periods of time, CBP provides inadequate and inconsistent food and clean water. CBP agents sometimes provide just a single bottle of water and granola bar, or a couple of crackers per person. CBP depends on volunteers to provide basic provisions for people at the OADs. CBP has even undermined class members' access to critical supplies by threatening volunteers with arrest. When volunteers are unable to provide humanitarian aid, the situation is dire. Children face medical emergencies and OADs with little to no assistance from Border Patrol. Border Patrol provides no first aid or medical care at OADs, even though many children arrive sick or injured or become sick while detained at OADs. When children are too sick or injured to remain at OADs, volunteers plead with Border Patrol for access to emergency medical services. Even when people can call for emergency care, ambulances sometimes refuse to come all the way to the OADs in Jacumba. I'm sorry, y'all. I'm sorry if I'm butchering that. I don't know how to pronounce it. They refuse to come to this particular OADs because of the remote location and rugged terrain. Some Border Patrol agents refuse to help transport non-citizens to the ambulances. Border Patrol agents must open a gate to permit ambulances to access non-citizens suffering medical emergencies. Border Patrol agents have also actively compromised access to medical care. For example, agents regulate access by medical volunteers and have at times barred medical volunteers from the sites. Border Patrol further undermines access to medical care by threatening people seeking medical assistance with the loss of the right to seek asylum. CBP directs children to OADs and imposes its authority there. Border Patrol instructs children to remain at OADs to await formal processing. In some cases, Border Patrol transports individuals to OADs and Border Patrol vehicles. Border Patrol also directs groups of non-citizens to follow Border Patrol agents or Border Patrol vehicles to OADs. Border Patrol agents decide which non-citizens can remain at which OADs. This sometimes even includes separating families. For example, Border Patrol routinely requires men to move to a site called Spooner's Mesa, and Border Patrol has separated fathers from their children to send them to different areas of the same OADs or to a different OADs. CBP has also separated male children from their parents. Quote, a mother said that Border Patrol agents had separated her minor son from her and sent him to the Spooner's Mesa OADs. The agent was dismissive of the concerns about separating the mother from her minor child. While at OADs, CBP agents instruct everyone present to stay within the site and to wait. They make children and others sit or stand in rows for long periods of time. If people are not seated or standing as instructed, Border Patrol agents yell at everyone, including the children. CBP regularly subjects individuals at OADs, including children, to counts, wherein they order individuals to stand in rows and then count everyone present. CBP agents sometimes conduct counts in the middle of the night, forcing people to wake up and leave their makeshift shelters to stand in the cold and the rain. Agents have required everyone, including children, to wear only one layer of clothing during the count. What? Parents have pleaded with CBP agents to allow their children to remain asleep under tarps during the count, but CBP agents deny these requests. CBP agents yell at anyone, including children, who attempt to return to their makeshift shelters without permission to leave. Some CBP agents are aggressive and vulgar towards the people they hold at OADs, including children. Per someone's testimony, CBP agent directed family to separate and responded aggressively in English when girls pleaded with agent to keep their family together. Children must remain at the OADs until processed by CBP. CBP instructs people to stay at their designated OADs and determines whether and when children and adults can leave the site. So, to ensure that people stay within designated OADs, Border Patrol threatens individuals with deportation or other negative immigration consequences if they attempt to leave. CBP agents have intercepted non-citizens who left in OADs and returned them to the sites. CBP agents have at various times issued wristbands to non-citizens to track their arrival and length of stay. The wristbands vary in color to reflect the date an individual arrived at the OADs. When CBP does not use wristbands, processing is chaotic and individuals are often processed based on how quickly they can get in line, rather than how long they have been at the OADs or whether they are particularly vulnerable. As a result, children and other vulnerable individuals remain at the OADs for longer periods of time. Although CBP sometimes prioritizes families with young children and other vulnerable people, this does not appear to be a formal policy, and at other times, CBP has processed single adults before families with children. In some cases, CBP agents have refused to prioritize unaccompanied children, even after these children were brought into Border Patrol's attention. Border Patrol appears to exercise discretion as to how quickly it processes individuals out of the OADs. For example, OADs have been cleared quickly in advance of visits from higher level DHS officials. These periods of faster processing then subside and the cycle of detention continues. Now for the argument. Children at OADs are in the legal custody of CBP and are therefore entitled to the protection guaranteed by the Flores Settlement Agreement. The Flores Settlement Agreement protects all minors who are detained in the legal custody of INS. Although the agreement's terms refer to INS, the Immigration and Nationalization Services, obligations under the agreement now apply to the Department of Homeland Security and the Department of Health and Human Services. A motion to enforce a settlement agreement essentially is an action to specifically enforce a contract. This court has repeatedly affirmed its jurisdiction to enforce the settlement and set out the principles for doing so. The settlement employs the formal meaning of legal custody derived from family law, signifying the right and responsibility to care for the well-being of the child and make decisions on the child's behalf. Children can be in the legal custody of both DHS and their parents. The parents of children in government custody do retain parental rights, and more than one person or entity can have legal custody of a child. The court previously held that children detained under Title 42 of the U.S. Code are Flores class members in DHS legal custody because, quote, DHS has the authority to make decisions relating to the welfare and legal status of the children. In that case, legal custody was illustrated by DHS's control over, quote, whether, when, and how they apprehend individuals, how minors are processed, where and under what conditions to detain minors, and when and whether minors leave DHS custody. CBP exercises similar decision-making authority over children held in OADs. Children enter Border Patrol's legal custody upon initial discovery and remain in Border Patrol's legal custody until they are formally released or transferred to the custody of another federal agency. Border Patrol has custody of non-citizen children from the moment of first discovery. CBP authority over a non-citizen child's welfare and legal status begins when CBP agents first encounter the child. When agents find a non-citizen child in the United States and direct them to proceed to and or to remain in any location, the child is subject to Border Patrol's control, and the Border Patrol can choose to transport them for formal processing at any time. Border Patrol's decision as to where to hold children and when to process them has profound consequences for children's safety and well-being, especially in light of the dangerous and unsanitary conditions at open-air detention sites. The Trafficking Victims Protection Reauthorization Act confirms that Border Patrol's legal powers and responsibilities related to unaccompanied children begin at the time of discovery of the child. It says requiring every federal agency to notify HHS within 48 hours upon A, the apprehension or discovery of an unaccompanied alien child, authorizing an immigration officer who finds an unaccompanied alien child from a contiguous country at a land border or port of entry to determine the child's admissibility and return the child to their country. Notably, Border Patrol's own national standards recognize its responsibility to make decisions affecting both accompanied and unaccompanied children's welfare from the moment of initial encounter, stating that, quote, officers and agents will consider the best interests of the juvenile at all decision points beginning at the first encounter and continuing through process, detention, transfer, or repatriation. DHS acknowledges that Border Patrol exercises custodial control over all non citizens it encounters in the United States and instructs to await processing. DHS recently represented to the U.S. Supreme Court that non citizens encountered by Border Patrol and directed to staging areas for processing have been apprehended and are not free to leave. Border Patrol cannot evade its responsibilities as the legal custodian of the non citizen children it encounters by holding them in OADs and delaying formal processing. The settlement explicitly contemplates that children will enter legal custody prior to formal processing and imposes an affirmative duty on Border Patrol to expeditiously process children. CBP has authority to determine where children are detained. When CBP encounters non citizen children, CBP, quote, decides where and for how long to hold them. CBP agents take a variety of actions after encountering non citizens along the border in the San Diego sector to control where they are held. This includes transporting individuals to OADs in CBP vehicles, using CBP vehicles to escort non citizens to OADs, directing non citizens to walk to a specific OADs, telling people at OADs to remain there, and separating families into different OADs. Although physical restraint via transport is not required to show custody, it is especially obvious that children are in CBP custody when they are transported to OADs in CBP vehicles. CBP's transport standards refer to the transport of detainees and make clear that non citizens transported in CBP vehicles are confined. These standards do not contemplate the possibility that CBP agents would transport non citizens who are not detained. The settlement similarly assumes that when CBP transports non citizen children, the children are in CBP custody. The settlement restricts the transport of unaccompanied minors with detained adults except in specified circumstances and requires CBP to take necessary precautions for the protection of the well being of such minors when transported with adults. This provision would have little meaning if the children CBP transports are not in its custody. CBP's authority to decide where to hold non citizens is also plainly illustrated by its practice of family separations. For example, CBP designates certain OADs, such as Spooner's Mesa, for adult men. This results in fathers being separated from their children, in at least one instance where a 17-year-old boy was separated from his mother. That CBP has had the power to separate families by sending some family members to different OADs who would otherwise choose to remain together demonstrates its custodial control. CBP's unilateral control over the conditions at OADs further underscores that children held at these sites are in CBP custody. CBP monitors non citizens at OADs and requires them to comply with CBP orders. For example, CBP agents conduct regular counts of non citizens at these sites. Even outside of formal counts, CBP agents sometimes subject non citizens to full body searches and instruct non citizens at the OADs to remain seated and yell at them if they try to move. At various times, CBP has issued wristbands to monitor when non citizens entered the OADs. CBP also controls children's access to basic needs. CBP provides extremely minimal services such as porta potties, small snacks, minimal water, and Mylar blankets. CBP also implicitly recognizes that it is not meeting the basic needs of migrants and depends on the generosity of volunteers to prevent an even greater humanitarian crisis. CBP nevertheless maintains control over volunteer access, preventing volunteers from entering sites like Spooner's Mesa, and at times threatening to arrest volunteers attempting to provide humanitarian assistance at other sites. CBP similarly blocks detainees from leaving OADs to access basic necessities such as food and water. Further, CBP controls non citizens' access to medical care, including by limiting access to emergency services and threatening families with negative immigration consequences for seeking emergency services. CBP unilaterally determines when non citizens can leave OADs. They control how long children remain before they are transported for formal processing. As in the Title 42 context, there appear to be no formal limits on children's length of stay in OADs. Children have been held at OADs overnight and sometimes for multiple days before CBP transports them for formal processing. At other times, CBP has rapidly processed all non citizens out of OADs, seemingly in response to upcoming high level visits or formal complaints. CBP instructs people to remain in OADs and regularly threatens non citizens with immigration consequences if they try to leave. CBP agents have even told volunteers that they believe individuals may fake medical emergencies to leave the OADs. That CBP agents express this concern demonstrates that neither CBP nor those they hold at OADs believed that non citizens are free to leave on their own. Indeed, at the San Ysidro OADs, non citizens are physically fenced in and monitored by CBP agents, making it unfeasible to leave without CBP permission. At the Jacumba OAD, CBP has installed surveillance towers and agents patrol the area on trucks and are regularly present on site. CBP has returned non citizens who attempted to leave these open air detention sites. CBP controls when non citizen children are able to leave, and these children rightly believe that they must remain at the site until CBP decides to process them. CBP's control over where and under what conditions children are held and when children are allowed to leave plainly demonstrates that they have the authority to make decisions relating to the welfare and legal status of the children from the moment of first encounter until the children's release or transfer to another agency. The settlement requires CBP to hold minors in facilities that are safe and sanitary that are consistent with CBP's concern for the particular vulnerability of minors. Specifically, paragraph 12.A requires defendants to provide access to toilets and sinks, drinking water, and food as appropriate, medical assistance if the minor is in need of emergency services, adequate temperature control and ventilation, and adequate supervision to protect minors from others. In its June 2017 order, the court found that the conditions in CBP stations in the Rio Grande Valley sector were unsafe and unsanitary. The Ninth Circuit agreed, explaining that assuring that children eat enough edible food, drink clean water, are housed in hygienic facilities with sanitary bathrooms, have soap and toothpaste, and are not sleep deprived are without doubt essential to the children's safety. CBP's abdication of its duties at OADs is far worse than CBP's egregious failure to adequately feed children at the Rio Grande Valley sector. When CBP provides drinking water, it provides insufficient amounts at best. This court previously found that safe and sanitary conditions require basic hygiene products like soap, towels, showers, dry clothing, and toothbrushes, and sleeping space. Yet CBP does not even provide shelter at OADs, let alone hygiene products, showers, or dry clothing. The only toilets available are unsanitary porta potties. If the conditions in the Rio Grande Valley sector did not comply with the settlement, conditions in the OADs are plainly non compliant. Moreover, open air detention sites are affirmatively dangerous places to detain children. It is impossible to comply with the settlement's requirement of adequate temperature control when children are left to sleep outdoors. Children have had to seek emergency medical care due to extreme cold temperatures. CBP fails to provide any medical care and sometimes impedes emergency medical care. CBP does not supervise minors, including unaccompanied children, even if they become ill or have other urgent needs. Being held in OADs is also terrifying, particularly for children. The dangerous environment CBP has created at OADs is fundamentally inappropriate for any child and in no way complies with the settlement requirements for safe and sanitary conditions. Paragraph 12A of the settlement requires defendants to ensure that children have contact with family members who are arrested with the minor. At the open-air outdoor site, CBP separates children from family members and does not ensure continuing contact. Children separated from their families are not informed of their right to communicate with their families, nor are they told what is happening, where their families have been sent, or if they will ever see them again. CBP fails to expeditiously process class members. Paragraph 12A of the settlement provides that whenever CBP takes a minor into custody, it shall expeditiously process the minor. In violation of the settlement, CBP fails to expeditiously process children and instead holds them in OADs for indefinite periods of time. The time children have been held can range from several hours to several days. CBP appears to have no set time limit on children's detention in OADs prior to formal processing and no clear policy to ensure children are expeditiously processed. Conclusion. Plaintiffs respectfully request that the court grant this motion and order defendants to comply with the settlement with respect to all class members held at open-air detention sites. Dated February 29th, 2024. Now we have the decision from the court. It says, plaintiff's motion to enforce settlement regarding open-air detention sites, which seeks a class-wide order requiring defendants, aka Biden-Harris administration, to comply with the settlement approved by this court on January 28th, 1997, came on regularly for hearing on March 29th, 2024. The court, having read and considered the parties' respective memoranda of law in support of and in opposition to plaintiff's motion, and having heard oral argument from counsel, now grants the plaintiff's motion. It is hereby ordered as follows. 1. All minors discovered by the Department of Homeland Security and in sites monitored by DHS, including but not limited to minors at the open-air sites at San Ysidro, California, and Jacumba, California, are class members as defined by paragraph 10 of the settlement. 2. As required by paragraph 12A of the settlement, DHS shall expeditiously process all class members. DHS shall place class members in facilities that are safe and sanitary and that are consistent with DHS's concern for the particular vulnerability of minors. DHS shall cease directing minors to open-air sites or holding minors in open-air sites, except for the amount of time DHS is actively preparing the minor for transport or transporting the minor. 4. If minors are detained in open-air sites for more than 2 hours after first discovery by DHS, defendants shall record the minor's name, date of birth, accompanied or unaccompanied status, length of stay, date and time of transfer to a safe and sanitary facility, and an explanation of the exceptional circumstances requiring delay in transfer. For a period of 6 months from the date of this order, DHS shall file monthly reports under seal with unredacted copies to plaintiff's counsel setting out the information collected pursuant to this paragraph. 5. As required by paragraph 12A of the settlement, DHS shall provide class members contact with family members who were arrested with the minor. This shall include all family members DHS encountered with the minor, including family members directed to proceed to and or to remain in open-air sites. Dated February 29th, 2024. Just the fact that if you Google, if you even try to find it, it's not that easy to find, for one. And for two, almost all of the headlines regarding this topic never said Joe Biden or Biden-Harris administration. It all referred to Border Patrol. Now, if you look up anything of the same topic regarding Donald Trump from his first administration, please correct me if I'm wrong, but as far as I know, every headline, Trump, 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 Trump. That's all I got for this episode, y'all. Until next time, please like, subscribe, comment, share this information because apparently not many people know. Apparently, AOC doesn't even know just how bad the Biden Harris administration has been treating migrant children. Someone please let her know because she needs to do another photo op, just something to let me know that she truly does care about the children. Oh, and also hit up Nancy Pelosi too, because she clearly cares about him too. And she apparently didn't know about this either. So that's all I got to say about that. Until next time, y'all. Peace. Bye.